Zayed, this is the wrong. Hello, everyone, and welcome to another insightful session here on Immigration Talk Show. And before we head on with our webinar for today and we have our guest join us, I have this very important disclaimer. And that is by watching our videos, you agree and understand that the information provided by our experts and attorneys, including comments and replies from users, is not legal advice. Use at your own risk. So, with that said, friends, thank you so much for joining us. We are streaming live right now on YouTube, and our handle is Immigration Talk Show. Don't forget to subscribe to us, hit that bell icon so that whenever we have discussions like these, you are notified. And best thing is that you can also participate in this, webinar today by commenting wherever you're watching us, and also by joining us on call. And to join us on call, all you have to do is dial this number 425-436-6335, and the access code is 988-888. So, yes, with that said, everyone, hi. Once again, I'm Nipasa. I'm going to be your host for today. And yes, today's discussion, we are going to really dive into this critical update, you can say, that could impact many professionals out there who are seeking permanent residency in the United States. US's latest guidance on the EB-2 NIW, National Interest Waiver. So the EB-2 NIW is a powerful pathway for professionals, researchers, and even entrepreneurs, who seek to bypass the labor certification requirement and even self-petition for a green card. So, but then, we recently had a few updates, and today we're going to discuss on how these changes are going to affect your application strategy and what you need to know to ensure a smooth process, and of course to help us and guide us through all these complications and necessary points to keep in mind. I'm very honored to welcome back our esteemed guest for today, Ingrid Perez. She is the managing attorney at her firm and a dedicated immigration advocate, having personally experienced the US immigration process at a young age after moving from Brazil. Well, Ingrid brings both legal expertise and deep personal understanding of the immigrant journey. So, hi, Ingrid. We're really happy to have you back. Thank you so much for joining us today.
Hi, Napasa. Good morning. Thank you for having me again.
Thank you so much, Ingrid. How are you doing? Has it been busy?
Yes, it's been very busy. I also changed offices recently, so that brings a whole bunch of change. But it's very exciting, and yeah, everything has been great.
Thank you so much. Thank you for joining us today. I'm already looking forward for this discussion that we're going to have, and I'm sure that it's going to be very insightful for everyone. So, yes, our topic of discussion for today, friends, is the National Interest Waiver, EB-2 NIW, and how will these latest updates impact your green card process? So, Ingrid, maybe you could tell us what can folks out there expect from today's webinar.
Definitely. I think we're going to have a very in-depth discussion about EB2 and IWs, the more recent policy guidance, as well as some clarification, that the new guidance brings about. I think it's also important to have a general overview so that, whoever, maybe there's somebody out there who's listening and maybe doesn't have as much knowledge about EB2 and IWs. I think it's good to also start with the foundation. But I think it's going to be a really great discussion, and we're going to open up to the listeners to ask questions, and so that people can, be more informed as they decide whether or not it makes sense to go about filing EB2 and IW.
Absolutely. So, with that said, friends, don't forget that you can ask your questions, you can participate by commenting. And yes, also don't forget to check us out. We are on LinkedIn, Facebook, X, Instagram, and feel free to join us. So, with that said, Ingrid, I think we will not wait any further. And I have this first question for you to answer, is if you can provide an overview of the latest USCIS updates, to the EB-2 NIW policy, and what key changes petitioners should be aware of right now.
Definitely. So I think that, before getting started on that, I think it's just really important to explain exactly what an EB-2 NIW is, right? So we have in immigration law 5 employment-based classifications, basically, EB-1 through EB-5. In the EB-2 category, right, it stands for employment-based second preference category. You can typically get an EB-2 classification through the PERM or through the NIW, which stands for the National Interest Waiver. So it's a two-part approach, right? First, you have to qualify for the EB-2 classification, and then if you want an NIW, which is a waiver of the labor test, the permanent labor certification and the job offer, you have to request a national interest waiver. So that is how it works. So I think for the policy manual, one of the things that they really are clarifying, and it's not really a change, it's really just a clarification, is that first you need to qualify for the EB-2 classification. And how do you do that? The most obvious way is by having an advanced degree, which is a master's degree or PhD. So that is the most obvious way. The other way that you can qualify is by having a bachelor's degree and 5 years of post-bachelor experience. Now, one of the things that the policy manual clarifies in regards to that equivalency, of a master or of an advanced degree, which is the bachelor's plus 5 years, is that your experience, your post-bachelor experience, has to be related to your field, right? It has to be related to your degree. So for example, if you are a chemical engineer, but your 5 years of experience post your bachelor's degree in chemistry is running a bakery, that's not going to qualify you for the EB-2 classification. So that's very important. And finally, the third way that you can qualify for the EB-2 classification is through an advanced degree. And that's meeting 3 out of the 6 regulatory criteria for advanced degree. Now, one thing that a lot of people don't maybe realize is that if you have an advanced degree, you don't also need exceptional ability. So, if you have an advanced degree or the equivalent, which is the bachelor's plus 5 years of experience, you don't have to also then show to immigration that you qualify for the EB-2 classification because you have exceptional ability in your field. So you can stop right there. So for example, if you are, if you have a bachelor's in mechanical engineering, and then maybe you have a master's in, another, engineering field, you can stop right there because you qualify for the classification by having your master's degree. So that is one of the things that they clarified in the updates. Another thing also that I think is worthy to mention is that the position for which you're trying to qualify for the NIW-4 has to be a professional position, right? So, we can think of the more traditional professional positions such as engineers, lawyers, doctors, etc., right? So it has to be a professional position. And this is tricky with the new updates because there are a lot of professionals whose positions don't necessarily fit within, the little cookie cutter box that immigration understands a professional position to be. So think about, entrepreneurs. However, the new guidance does give some specific considerations for entrepreneurs as well, and how an entrepreneur can qualify for a national interest waiver. So those are sort of, the basic changes, or not the changes, but the clarifications in the new policy guidance. I think it's also important to note that, over the last few years, there has been so many EB-2 NIW petitions filed by people both inside of the United States and by people outside of the United States. And this really came about after the January 22, guidance that opened up this possibility, right? Or not that it opened up, but it just encourage people with STEM degrees to apply for EB-2 NIWs, right? Because the US government recognizes the importance of people with these specialized degrees to contribute to advancing very important critical technologies. So what ended up happening is that a lot of US companies that would normally go through the perm process started to explore the NIW for their employees, right? A lot of software engineers, a lot of people in IT, cybersecurity, people that perform, these services that are working in a STEM field, but perhaps, the benefit of their endeavor, the benefit of their work is more towards the employer and not necessarily to the national interest of the United States. And the biggest takeaway, I think, from the updated guidance is that your proposed endeavor to the United States has to have broader implications. It has to meet the criteria of national importance. You have to show that it has implications to that you are advancing an important strategic interest for the United States. If the benefit alone is to your employer, that is not going to work. However, the policy guidance gives us some examples of situations where maybe the benefit is to the employer, but you can still show a broader impact, right? And I think the example that they use here is, for example, if you are working with pharmaceutical drug development, right? The benefit is going to be to your employer, but the broader implications of that is to the health industry, to the health field. You are perhaps, introducing a new solution to a disease or a new treatment to an illness or something like that, that has a broader implication to the field and to the national interests of the United States. So those are sort of like the themes that we're working around. It's really just clarifying that petitioners still need to show that in order to qualify for a national interest waiver.
Right, Ingrid. Thank you so much for that, sneak peek into the recent updates with what the USCIS has brought about for the EB-2 NIW. And with that said, I'll just say quickly, folks out there, you can join us with your questions as well. That we will take them up soon or later in this webinar we're having today. So next up, if you can also tell us about what petitioners should keep in mind and how these updated guidance impact the evaluation of professionals who are seeking this NIW based on an advanced degree.
Absolutely. So I think that, a lot of people qualify for the EB-2 classification because they have an advanced degree or they have a bachelor's degree plus 5 years of experience in their profession, right? So they qualify for the EB-2. But that is not enough. We have to go one step further to the national interest waiver. And I think that, the evaluation of whether or not somebody, qualifies for an NIW really is understanding the impact of their work, right? So understanding what problem does their work solve, right? So I'll give you some examples. And I think that, people may say that automatically a lot of people in tech may not qualify, but I think, painting such a broad brush is, not necessarily the best way to go about it. It is very much an individualized approach. And I'll give you an example, right? For a client whose EB-2 NIW petition I had approved that worked in tech. Now, this person developed technology for the big tech companies like Facebook, Facebook is the same thing, but for Meta, Microsoft, and Amazon. And the technology that he worked on was to screen and identify fake information online, right? So fake information about vaccines or fake information about the election, anything that had to do with the things that end up going viral and fake on the internet, right? That people a lot of times share over and over and over, that actually causes a disruption to our society. And that is what he worked on. That is a technology that he worked on for these specific types of employers, right? And the argument here, the reason why I decided to take that case, even though, he's working for these big companies and the benefit is to the employer, right? This big tech company that could easily do the perm process, is because the broader implications of his work, right? having, less fake news or fake information or false, misinformation online is actually in the United States interest, right? We have the Surgeon General that talks about how fake information online affects our mental health and it affects our decision making, right? And it actually, there's a lot of, instances where fake information has caused panic, and once false information is out there, it's very difficult to contain it back, right? Or address it and explain to people that no, this is fake, because clickbait is what sells. So we are able to show that it is in the national interest of the United States for him to work on this technology, and we really emphasize the broader implications of the technology, right? Even though he's working to develop these algorithms and using AI and the software and whatnot. So you always have to think about the broader implications of your work. So if, unfortunately, I think for most people who may work in software development or IT, and, they're working on developing, a portion of the cloud or working on something like that, the benefit is directly to the employer. It's hard to answer the question, what is the broader implication of your work? So I think those individuals are going to have a much harder time with an NIW versus an individual whose work actually has, a broader implication, a national level impact that addresses something that the United States finds important. Petitioners should really be aware of this. And, of course, there will be attorneys who still represent, these petitioners that maybe don't qualify for an NIW. But I think that for people who are looking to file EB-2 NIWs, understanding this and being able to articulate an argument towards a national interest is really important. And, it is a discretionary benefit at the end of the day, and you want to have the best opportunity to get your case approved. So it's important to keep that in mind.
Thank you so much for taking that up, Ingrid. And at this moment, I would say hi to Richard Coelho. We are going to take your questions very, very soon. Richard, stay with us. And folks out there, don't forget to subscribe to us. We are at Immigration Talk Show. We are on YouTube, LinkedIn, Facebook, X, and on Instagram as well. Check us out. And do call us, to ask your questions to directly to Ingrid as well. You can call on this number 425-436-6335, and the access code is 988-888. So, Ingrid, now my next question to you is, with all these changes happening, how impactful are these changes, especially with regard to the processing time? Is it going to make it more lengthy, the process, by any chance?
Well, I mean, I think that we started to see a lot of, you know, um, changes with USCIS and the way that they adjudicate the EB2 and IW petitions, sort of, in the middle of 2024 up until now. There was definitely increase in requests for evidence for a lot of EB2 and IWs that were filed. There are a lot of EB2 and IWs that were filed with premium process, and USCIS did not, complete the adjudication within the 45 days. I know that in my office, I have a couple of those cases, where we requested premium process and USCIS did not meet the deadline. I also think, obviously, with the change in administration and the things that are going on with, the employment, the federal workforce may cause delays as well. And of course, whenever there is, a policy change like this, on top of an administration change, I think there will be some recalibration that needs to happen within USCIS. I haven't seen or haven't heard of any indication that the Trump administration is going to rescind, anything related to the EB2 and IW, but I do believe that we will have higher scrutiny. I can tell you that last year I did have some consultations for people who had filed EB2 and IWs, had received RFEs, responded to the RFEs, the cases were approved, and later USCIS rescinded the EB2 and IW approval. And the pattern that I saw was, these were mostly people outside of the United States who were filing EB2 and IWs. And the endeavor, although USCIS found that the endeavor had merit and national importance, they did not find that the professional, that the petitioner was, able to advance the endeavor. So they were questioning a prong that I hadn't really seen before, because usually USCIS questions the national importance and the merit of the endeavor, really just the national importance. So it was interesting that I saw these, these cases that were later rescinded. And I think that, a lot of times people who are outside of the United States propose endeavors that are unrelated to their profession, unrelated to their experience, unrelated to what they really do. So I'll give you an example. I had a few process engineers with long careers in the industry submit endeavors that were about opening a business, right? A business that was going to hire employees, and maybe the business was in their field, but they did not have any experience as an entrepreneur. And they submitted a very elaborate business plan that had financial projections, stating that the company was going to make, millions of dollars and hire dozens of employees. And USCIS started to question, can you really make this happen? What do you have already going, to show that you are well positioned to advance this endeavor? So I think that, having a degree alone is definitely not enough. You have to be very thoughtful with the endeavor, and you have to be very thoughtful with all three prongs of the NIW. So I thought that was very interesting, that I saw these trends. And I think that, it'll be interesting to see what happens over the next few months with the EB-2 NIW adjudications. For sure, every case that is pending is going to be adjudicated now based on the new guidance. So, you can expect more RFEs perhaps, but I think eventually it will sort of settle down a little bit. People will be more cautious with the types of cases that they submit. Perhaps big companies won't be filing as many EB-2 NIWs and reverting back to a more traditional route like the perm. So I think eventually it will sort of settle. I like to say that USCIS had buyer's remorse from the 2022 guidance, encouraging a lot of people with STEM degrees to apply. And that's why they issued this new guidance in January 2025. So, we have to wait and see, but that's my prediction.
Thank you so much, Ingrid. Yes, I think seems like it as well. So we'll just have to wait and watch what happens. But nevertheless, folks out there, here's wishing you all the very best. Everything is going to be fine. All you need is an immigration attorney to guide you in the right path. So why not contact attorney Ingrid Perez as well? Her information is scrolling on the screen. You can check it out. And at this moment, I'll also say hello to Yash Patel, Imran, Fawad. Thank you so much for joining us. And we should just quickly address a few questions from the audience as well right now, Ingrid, if you don't mind.
Absolutely.
Let's take up Yash's question. How does civil engineers in infrastructure industry stand with recent updates?
I think that civil engineers, in infrastructure perhaps have good cases, right? Because infrastructure is an industry that is very important to the United States. The United States has been investing billions of dollars to upgrade our infrastructure. And when you think about the United States infrastructure, there are so many aspects to it that needs work, right? So bridges, our water systems, right? Perhaps public infrastructure, highways, all of these things, right? And I think that for a national interest waiver argument, right, I think it's really important to focus on the niche and understand the benefits that the work of the civil engineer is perhaps bringing to the community, right? Bringing to urban planning, bringing to the United States. Maybe what types of methodologies and practices are they implementing that are new and advanced? Are they helping address an important environmental consideration, right? Because every time we build, there are environmental considerations as well. Are we building our buildings in a way that they will, withstand natural disasters, extreme weather or things like that? Are we building the buildings of the future, right? And the infrastructure of the future. So I really enjoy working with with various types of engineers, civil engineers, definitely for sure. And there's so many specialization and there's such a niche, that people can really focus on. And I think hyper focusing on that niche and the importance of that niche and that expertise and the overall benefit that the work of the civil engineer brings about to important interests of the United States, right, is the key. So I think that for civil engineers, if they're working on something like that in the United States, I don't think that this policy guidance affects them too much, right? We just have to, again, hyper focus on the broader implications of the work and not just focus on the fact that this, is going to be perhaps creating economic movement for the employer or, having attenuated benefits. I think we have to focus on the direct benefits of the work, right? And also not focus too much on the fact there may be shortages, because that is not what the NIW is for. The NIW really is focused on the importance of the endeavor. And that is a conversation that I have with, everybody that comes to me is, what problem are you solving? What are you improving? How are you making America better? In what specific way? And that is what we have to explain to USCIS.
Very well put, Ingrid. Thank you so much for taking that up for Yash. And Yash, I hope you've gotten your answer. If you have more questions, you can keep commenting. And also, don't forget to subscribe to us if you haven't already at Immigration Talk Show. All right, so with that in mind, whatever you just said, answering to Yash's question, my next question is also about individuals, who are claiming to have exceptional ability. So, how does USCIS access whether their ability is directly related to their proposed endeavor?
Absolutely. I think that's a great question. And it reminds me of a conversation that I had yesterday with a potential client. When we got into their qualifications, they worked in this very specific field in the finance industry. And when we started talking about the types of evidence that they would have to show, they definitely qualify for the classification by having an advanced degree. But I also like to delve into those exceptional ability criteria because I use that evidence to argue that the person is well positioned, right? So when we started talking about the different recognition, the different accolades, and the different achievements that this person had throughout their career, they started talking about more of unrelated aspects of their specific profession. So, for example, this person worked in finance, but they were leading an initiative within their organization to hire more women, and people in finance. That was very unrelated to her endeavor, right, of working in this very specific niche of finance. Or perhaps, you do a 5K to benefit an organization or a charity or something that is related to the company. That again is unrelated to your field. So those things should not be considered when you're talking about exceptional ability. The exceptional ability really needs to be related to your field of endeavor, right? So if you are a person with exceptional ability, let's use the civil engineering case, for example, right? Recognition for the projects that you have done, right? Have you received, contracts that, you were able to maybe outbid, or maybe you have received recognition from the city or the municipality that you've worked in, right? Has the bridge that you've built or, the school that you helped build received some type of recognition in the press or something like that, right? It has to be directly related to your profession and your endeavor. So I think those are the specific considerations that USCIS will, address, and they are not going to consider things that are unrelated, right? Things that I guess, in the real world, we call more of like the soft skills, right? Or those things that you do to build culture or something like that. So that's what you have to keep in mind. And that is what, USCIS is going to do. And it's always how they've done things, right? It's nothing new. It's just clarification for future petitioners, because again, like I said, I really think that USCIS had buyer's remorse, right? And they are now kind of tidying this up a little bit and telling people, wait a minute, hold on, don't just dump everything and expect to get approved. You really have to narrow your focus and present a case that complies with the regulations and the requirements.
Thank you so much for taking that up, Ingrid. And folks out there, stay with us because there's so much to speak on today's topic. And we are speaking today about the latest updates on the EB-2 NIW by the USCIS and how it is going to impact your green card process. So, folks, also, if you want to contact attorney Ingrid Perez directly, you can give her a call on her number or email her. Her number is 407-906-0068. And you can also email her about your case and maybe ask for her guidance by emailing your information to info@ibplaw.com and go visit www.ibplaw.com to get to know more about Ingrid Perez and IBP Law. So, with that said, we are going to take a short break right now and we'll be right back to speak more. And Yash says, thank you. Thank you, Yash, for your question as well. Keep commenting and keep watching. Stay tuned, everyone. It's me, Napasa, and Ingrid Perez right now on Immigration Talk Show. Hello, everyone, and welcome back to Immigration Talk Show. I'm Napasa, your host for today, and we are having a very, very interesting and insightful webinar with attorney Ingrid Perez from IBP Law Firm. And the topic of discussion is how will the latest EB2 NIW updates impact your green card process? I hope that you are having fun, listening to all these new updates and what to keep in mind. I hope you're also noting down the most important points. So, yes, with that said, Ingrid, I hope you're also having a good time answering our questions and also, answering to folks out there. Yash says thank you once again. So, here they are. Richard, just stay with us. We are going to take your questions, Fawad as well, and also Imran. Stay with us, all right? So, Ingrid, my next question to you is also if you could tell us what factors, does USCIS consider when determining whether a proposed endeavor has national importance under the new guidance?
Absolutely. So I think just going back to what we talked a little bit about before, right?
Yeah.
I think the simplest way to understand and to present this to immigration is what problem are you solving, or what thing are you improving? What innovation are you creating, right? And how are you impacting your industry, right? How are you impacting your field? So those are the questions that petitioners should be ready to answer when they are preparing an EB-2 NIW petition in discussing the national importance of their endeavor. And how do you prove that, right? So, obviously, a petitioner's words are great, but us just saying that an endeavor has national importance is not enough. We need to back that up with documentary evidence, right? And I'll tell you how I do it in my office, right? Of course, I always start any case with an in-depth discussion with my client. And before I have a discussion with a potential new client, I do a little bit of research on their field, right? If it's a field that I'm not necessarily familiar with. I'm very familiar with engineers and researchers, so those cases come a lot natural, much more naturally to me. But for fields that maybe I'm not so familiar with, I start with always doing a little bit of research, right? What are the trends in the industry? What are the problems? Where are the gaps in the industry, right? And how is this person helping to address those things, right? So starting from that. And then really trying to understand, from the client's perspective, what is the impact of their work? How do they go about doing it, right? Like, what is their day-to-day like? What does their team look like? How is the decision-making process, in their profession, right? How do they, perform their tasks and their activities? I really like to understand every single aspect of my client's work so that I can understand it, say it back to them in a really easy way. And if I feel confident that I can, explain it to my client in a way that they say, yes, that's exactly what I do, I'm able to then explain that to the immigration officer. And I always do my cases assuming that the immigration officer is a blank slate. I assume that they don't know anything about the industry. And I also assume that they are overworked and overburdened. So I want to make this easy for them to understand, and I want to make this simple for them to understand as well, right? So I think that having a very clear theme throughout an NIW proposed endeavor is very important, right? Always hitting that theme, starting with your topic sentence and having that theme discussed throughout the endeavor, right, is really important. And having corroborating evidence to back up what we're saying, right? So at this point, I am doing research about, the specific problem that my client's work is addressing. So maybe I'm looking at, studies or government reports, or maybe articles from, credible sources that talks about where the industry is going, what are the gaps, what are the failures, and, maybe, information that I can find that talk about a specific aspect of my client's work and how that is helping solve a problem, right? And then that way I can make the connection to the immigration officer. Look, I have all of these credible sources that talk about how, this solution is one that is being widely adopted, or this solution is what is going to drive the industry forward. And this is exactly what my client is doing, right? He's doing this, he's been doing this, or she's been doing this for years and years. And here are a bunch of examples of him or her doing this exact same thing that the industry is saying is needed. So that is how I tell this story and how I bring this theme throughout an NIW petition. So I think that is what USCIS has always considered and will continue to consider, right, in determining whether or not a proposed endeavor has national importance. They want a detailed plan of the endeavor, right? It doesn't necessarily need to be a business plan. It doesn't necessarily need to be an elaborate document that you invest money in purchasing. You can create this document itself. You just have to understand how to structure it, how to tell the story. It has to be simple. You have to explain it in simple, clear ways. And the evidence that you submit has to back it up, right? It has to be relevant. So I like to, assume that the immigration officer has maybe an hour to read your case. What are the things that you want him or her to come away knowing about your case? You don't want to have them confused. You want to be super clear, direct, and succinct with everything that you submit to USCIS.
Right, right. Well, thank you so much. These were such important points, and I hope that it's going to be very beneficial, folks out there who are watching us, and that you have taken notes because they were very important points that Ingrid just gave out. So, with that said, Ingrid, also if you could tell us about the documents that are most important. How should petitioners strengthen their applications, particularly in providing letters of support and business plans as well, to demonstrate that they are well positioned to advance their proposed endeavor.
Absolutely. So I'll start with business plans because I have a lot of opinions about business plans, at least in how I do cases. I don't submit a business plan unless the endeavor is entrepreneurial. That is just how I approach the cases, because to me, a business plan is very specific. It has very specific information. It has financial projections. The considerations about the business that you're going to start, where the business is going to be located, who is going to be your target client or your target customer, how are you going to expand the business, how many employees are you going to hire, what is going to be your role in this business. So I think a business plan that has all of those things, and those are the exact things that USCIS in the new policy guidance has a special section, like has a section just devoted to entrepreneurs, right? I think that is important to discuss, especially if you're thinking about an entrepreneur endeavor. Creating lots of jobs is something that could be in a national interest, right? And I'll give you some examples. I'll give you an example of an entrepreneurial case where I've submitted a business plan. I had a client who started a business in his country, and the business was buying used equipment, used industrial equipment that maybe was not working from the government, or maybe from businesses that went out of companies that went out of business. And he would buy these equipment, he would refurbish them and resell them into the secondary market. And he had years doing this, and he was able to grow his business, create lots of jobs in his home country, and he wanted to replicate this business here in the United States. From his country, he hired someone in the United States, and he set up an office, and he started doing just that. And from his country, he was able to manage the operations here in the United States, grow it to some 7 or 10 employees at the time that we filed. And he was operating for some time. He was entirely remote, and the business was thriving here in the United States. And he was doing the exact same thing, right? And the argument here was that he was adding to the secondary market, right? He was adding to our circular economy, helping to keep these machinery parts, these equipment, all these things out of our landfills and available to perhaps new businesses, new manufacturers, new factories that are just starting out and maybe don't have the money to be able to buy brand new equipment, right? It's also very important to have these secondhand machines and parts available in case of a supply chain shortage, right? So he's supporting the industry in so many ways. And this was a legitimate business. He had plans to grow and expand, and he showed a history of doing exactly just that, right? And I had even his bookkeeper write a letter on his behalf. And that was a case that I think really warranted a business, because his endeavor was truly entrepreneurial in nature, and he had the proof to back it up, right? So that's my feeling about business plans. I really only submit them when the endeavor is truly entrepreneurial in nature. As far as letters, right? Letters is an interesting one, because letters are very important to a case. However, a case is not going to stand on letters alone. You still need corroborating evidence, because immigration kind of snubs its nose towards letters, because letters are created for the purposes of a petition. So instead of calling them letters, I started calling them testimonials, right? Because testimonials are more objective. So I've been writing, these letters in a way that are very objective, very descriptive, right? We're not writing character references. We're really writing testimonials about the client's work. I like to tell my clients to include a lot of quantifiable information in these letters, right? To describe what was the situation before and what was the situation like after, the client stepped in to work on a specific project or handle a specific, solution to something, right? So I think letters are very important. The guidance also talks about letters from government agencies or quasi-government agencies that are interested in one's work. And those letters are very powerful because they can hit all the prongs, right? Depending on the information that's in them. And, USCIS also says in the new policy guidance that the letter should be from experts in the field who are familiar with you and your work, right? But at the same time, they always, they often snub their nose at letters. So I think the letters need to come from a mix of individuals, a mix of experts who are familiar with your work and that know you, so that you're not just, submitting a case that is full of letters from your employer or your colleagues or your managers. I think it's really important to have a mix of letters to show broader impact. So I would say, for people who are going through the EB-2 NIW process, tap into your network, keep those connections alive. Keep the connections with your professors. I think letters from professors are a very a great way to get a letter from an expert, right? Professors are in academia and they have a lot of expertise. And if you can get a letter from your professor that can say that your work is important, that professor will be some years removed from your work, but they know you and they know the industry and they know what you're doing. And I think those letters can be very powerful if done the right way.
Thank you so much. So, testimonials, as Ingrid calls them, I think they're very, very important. So, thank you, Ingrid, for taking that up and for answering to our question. We also have RK join us. Hi, RK. Thank you for joining us on YouTube. He's asking, can you speak to the timeline from start to finish, green card, for these applications? Maybe briefly, if you can just give us the timeline, Ingrid.
So definitely. So if you're starting and you don't have a prior petition that has been approved, right? So the date that you file your petition with USCIS is the date you get in line for your green card. So let's say, today is February 28th, 2025. Your petition arrives today at USCIS. Today will be your priority date. Today is the date you get in line. Now, that petition may take, anywhere from 45 days if you're requesting premium process to maybe a year for a decision, right? And that timeline doesn't really matter so much anymore because the visa bulletin is so backlogged, right? So the visa bulletin is the other thing that people have to keep in mind when thinking about the green card timeline, because your priority date, right, in this case, February 28, 2025, has to show up on the visa bulletin before you can even apply for a green card, right? So timeline is kind of like one of those things where it's just, depending on what's happening in the world of immigration, it's very relevant, right? So I would say that right now, average, if you're not, born in a country like India, which has a significant backlog, if you're with the rest of the world, I would say 2.5 to maybe 3 years, right? Premium process, I think, is important to note that premium process only gets you a decision faster. It does not get you the green card faster. It does not get you the ability to apply for a green card faster. So I don't recommend premium process to most of my clients unless there is, a necessary reason for it. Like, for example, maybe they're running out of H-1B time and they need to have a decision on the I-140 so that they can keep extending their H-1B. Or maybe they're just really curious, or maybe they have an earlier priority date that they want to capture. Those are the situations, the circumstances that I think premium process could be a good idea. Otherwise, I would say save your money and just be patient and wait.
Thank you. Thank you so much, Ingrid, for taking that up. And yes, the premium processing is very expensive, but good to know that you don't just suggest that to anyone and everyone, Ingrid. So RK is also asking another question before we can move out to our Facebook questions. Here's one more question. Also, what is happening with premium processing for EB-2 NIW? Do you see them temporarily discontinuing it to clear regular processing backlog?
I don't know if that's why they are, maybe not adhering to the EB2 and IW premium processing timelines. I just had an EB2 and IW approved yesterday or the day before for an agronomist, and we filed a premium process, and it was approved close to the 45-day mark. No RFE, thank goodness. I also have a few cases that I'm working on right now that we filed premium process. We received RFEs, and now we're working on responding to these RFEs. And then the clock is going to pick back up, right? USCIS has then additional time to decide these cases. But I think that, because so many people were applying for EB-2 NIWs, they naturally wanted to go with premium process. And a lot of these companies that perhaps can afford these very expensive fees were filing premium process just to see what would happen. I think it definitely created a demand for premium process that USCIS simply does not have the supply to meet, right? So I think that's what's happening. USCIS does have the authority to discontinue premium process. If they do, I would assume that it may be to, clear the regular processing backlog, which I think is significant, right? I have cases right now that are pending quite some time, even beyond the normal processing times. So for sure, if they decide to do this, I think it may be for that strategic reason.
Right, right. Thank you so much, Ingrid, for taking that up for RK. And RK, thank you for participating with your questions. And Ingrid, we also have some questions from our Facebook group, so we'll quickly address to them. This first one is already on the screen. My employer is not sponsoring me perm EB2, EB3 skilled. I am on H1B and my wife on H4. Can we apply EB3 unskilled for my wife as a principal applicant? And if approved, will it have any impact on my H1B status? Or can my wife get EAD till we both get the green card?
Okay, so to answer the first question, will your wife's EB-3 unskilled have any impact on your H-1B? No, because it just doesn't. It's completely separate. You can continue to have your H-1B. It's not going to have any impact on your H-1B status, right? Can your wife get an EAD till we both get the green card? Well, if your wife is on H4 and she has an EB3 visa petition available for her, she's not going to be able to get the EAD until she files for the green card together with the work permit application, right? So she'll be able to get the work permit after you file for the green card, and you presumably have filed the work permit application as well. But having the petition in and of itself approved for her in your specific situation is not going to give her an EAD. However, if you on H1B, if you were able to get an approved I-140, then your spouse on H4 would be able to get an EAD, right? So if the role, or if the I-140 was reversed, right, then your wife would be able to get an EAD that way. So yeah, I hope that helps.
Thank you, Ingrid, for taking that up. And now we have this next question. This is from Duda. Is there a possibility that the Trump government will expedite people with an EB3 visa who are document qualified, being able to have the right to go and work in the US before the interview? My PD is 7822. You guys think will be current until middle next year?
Incredibly hard to tell. I mean, there are so many changes going on with, the Trump administration. We're still within the first 100 days of the Trump administration. And we know that, as of day one, he instructed the Department of Homeland Security and the various agencies to look into immigration processes and everything that's going on and make recommendations. So this is one that I really I can't, unfortunately, I just don't know the answer. I can't look into the future, but, my inclination is that no, I don't think that he's going to be doing anything to really make it easier for people. I could be wrong. I hope I'm wrong. Maybe, in the employment-based context, I will be wrong. But just knowing how the administration operated, during Trump 1.0 and what's going on right now, I don't think he's going to make it any easier for people, unfortunately.
Okay. Thank you, Ingrid, for taking that up. I got this next one. This is from an anonymous member. My PD is November 2021. Anyone have how long it will take more?
Nobody knows. Nobody knows. I wish I had a crystal ball. If I did, I would, be very popular. But nobody knows, and I think it also depends on the classification. We'll see what happens, because we do have a new fiscal year in October, and every quarter these things sort of recalibrate, right? It may be that with the less premium process cases. USCIS has the ability to adjudicate more green card, petitions, and therefore make at least a green card application more available for people. I mean, that is one possibility, but we'll see.
Yes, we will. Well, thank you so much. It's really hard to tell, to predict, but thank you, Ingrid, for taking that up. And now I got this next question. This is from Anil. Hi, everyone. I am F1 student in USA. I applied to EB-3 unskilled worker. My priority date is December 18th, 2023. Do you have any idea how long will this process take to apply change of status from now on?
I assume that you are asking how long it's going to take to apply for adjustment of status, because if you're in the US with F1, you can change your status. There's just just a terminology just to make sure. So I assume she's talking about adjusting her status to get a green card. And again, it's just impossible to know.
I know it's so hard when they ask about dates and priority dates, it's just hard to tell. So, yeah, thank you, Ingrid, for taking that up. And this next one is, hey, I am an F1 student and my I-140 approved, and my PD is March 2023. How long will it take for the next step? It's almost similar to the previous.
I don't know. Watch the visa bulletin.
This next one again, this one is from Bangladesh. I have applied EB-3 unskilled from Bangladesh. My PD is December 2023. I hope in the upcoming April, my LC will be approved. Now, after receiving my LC, if I change my sponsor and company and go to another sponsor and company, then will I be able to complete and continue my process from there? Is it possible? Also, if I change sponsor and company, will my PD be the same? Please let me know.
I can't tell if you have, I assume the LC means the labor certification. You don't have an approved I-140, so you're not going to be able to keep that priority date. I would say talk to the attorney who's doing this for you, but I assume that that's what's happening here. It doesn't seem that you have an EB-3 yet. You're still in the labor certification process.
Yes, thank you, Ingrid. I think those were my Facebook questions from our groups. So thank you for taking that up and addressing them patiently. I think we should quickly take up a couple more from our audience here. So let's go with this first one, which is from Richard, asking, I'm an engineer with 10 years of experience in renewable energy. I've been working on sustainable infrastructure projects, but I don't have a PhD. With the latest EB-2 NIW updates, how do I prove my work has national importance strong enough to qualify?
I would want to know the types of projects that you're working on. Renewable energy is, I think, very important to the United States. There's a lot out there that will help you discuss renewable energy and the importance of the field. The next step is the importance of your work. So understanding exactly what you do as an engineer working renewable energy. Are you developing new technology? Are you installing renewable energy technology? Are you designing? So I think understanding exactly what your day in, day out work is very important to be able to argue that not just the industry is important, but that your specific endeavor, your specific activities are important to advance this field. So I would say that, when I talk to engineers, what I like to know is, just that. What exactly do you do? What are the types of projects you're working on? What types of documentation do you have to show that you have been successful in your career, that you have had an impact? So perhaps you can share, work orders or designs, or maybe there's some, press releases about the different projects that you're working on, or maybe there are some scientific studies that must be done before, you implement a renewable energy sort of, machinery or whatever, right? Whatever it is that you're working on. So maybe there are some quantifiable information that you can show that, this renewable energy has had XYZ impact in whatever town or location or people, whatever, right? Um, and I think sustainable infrastructure projects are important because there's a lot of studies out there that I think you could use to show the impact and the quantifiable impact, right? Specifically about different sustainable infrastructure projects. I don't think you necessarily need to have a PhD. If you have a bachelor's degree with your 10 years of experience and you qualify for the EB-2 classification through the equivalent of an advanced degree, if you have a master's degree, you also qualify for the classification. You don't need a PhD. I do cases for people who are industry professionals all the time, and it's all about understanding what they do and how to best present that information to USCIS.
Thank you for taking that up. Richard, I hope you've got your answer. I'd like to take this next one. This is from Imran, and this seems very important as well, to get to know will it impact or not. I started my EB-2 NIW process last year, and my case is still pending. Will the recent policy changes impact my application, or will USCIS evaluate my case based on the previous criteria?
They're definitely going to evaluate your case based on the most recent criteria. So
Okay.
if you believe that your case was maybe, not presented in a way that best addresses the new criteria, I would recommend go online, print it out, study it, read it, maybe start preparing for, a response, an RFE. I mean, that's worst case scenario. I don't want to like scare anyone, but in the event you do get an RFE, you need to be prepared because you do have a limited amount of time. And I think, learning and reading about the new policy guidance and, maybe talking to the attorney who did your case for you could be a way to help you at least prepare, right, for in case you get an RFE.
Thank you, Ingrid, for taking that up. Let's take up Fawwad's question. He's saying, I am in academia working on biomedical research and I have several published papers. Given the latest updates, how much weight does USCIS now place on publications and citations when considering an EB2 NIW case?
USCIS has always given consideration to publication and citations. I think that researchers, especially for a person who's working biomedical research, I would really like to look at this case. This is one where you are advancing healthcare, right? You're advancing biomedical research in the United States, which is an area that is very important to the United States. If you are a researcher in this field, right, you are researching innovations, you are coming up with new solutions, you are, coming up to answers to problems. So I think that for researchers, those are still really great. Most researchers, I would say, right, probably have great cases for EB2 NIW. Actually, matter of Danosar, which is a seminal case that deals with the NIW, that was for a researcher. So I like researcher cases. I like them a lot.
That's very nice. Fawad, thank you for participating with your question, and Ingrid as well for answering to Fawad. Next question that I want to ask is, Ingrid, what are the implications of these, updates for STEM professionals and entrepreneurs, given USCIS's previous guidance in these areas?
I think that for STEM professionals, for many STEM professionals, the EB2 NIW is still a viable route. A lot of STEM professionals work on advancing technologies that are critical to the United States, right? We have the critical and emerging technologies list. People who are working to advance those technologies, I think, may have still, great NIW cases. It just very much depends on who is the ultimate beneficiary of your work. What are the broader implications of your, innovations, your work for, right? I think that is the differentiator for, STEM professionals. If you're working with a company, an employer, and you're developing technology for that employer, you still need to show that that technology is in a national interest, right? That technology has broader implications, and then perhaps the advancement of those technologies are important for the field. So those are the implications that you have to keep in mind. So again, just think about, how to present a more whole case where the evidence is not just coming from your employers, right? Where the letters are not just coming from your managers. And I have my dog here in the office, which is why you're hearing barking. But, think about that. How can your work really have that broader implication? And I think that, I do like working with STEM professionals as well. And I think a lot of people may still have good cases, just about understanding the requirements and what USCIS wants and best presenting that information, the evidence.
Yes, absolutely. And I think you, as attorneys, you know best and how to impress. So, I would say, folks out there, it's always best to, consult an attorney with your case so that you are guided in the right direction, and you know what to do. So, yes, attorney Ingrid Perez's information is on the screen. You can note it down to contact her. You can email Ingrid info@ibplaw.com, and you can also call Ingrid at 407-906-0068, and go visit www.ibplaw.com. And Ingrid, before we leave, I would like if you could tell us if there are any specific filing tips or strategies that applicants should follow, to improve their chances of approval under the updated guidelines.
That's a good question. I think that, I'm always impressed with the people that I talk to about EB-2 NIWs, because I think they're usually very knowledgeable. I think knowing what USCIS, is looking for. I mean, obviously, you don't have to be an attorney to read the guidance, but I think that becoming familiar with what immigration is looking for is really important, right? And I think also having a very niche and focused approach to an EB-2 NIW will help improve your chances of approval, right? So focusing on the endeavor, focusing on the work that you do and how you're well positioned to do that specific endeavor. Be strategic with the types of evidence that you're including, right? And be strategic with the letters as well. A case should not be filed with, many letters. I don't think you need that many letters. 7, 10 letters. It's too much, because the letters are going to be repetitive, and USCIS is not going to give those letters a lot of weight. So I think narrow down your focus, identify the people who will write the testimonials on your behalf, and be very strategic. And each person should say something different, right? I don't think that having multiple people say the same thing is good for a case. I think it becomes redundant. And think about the immigration officer who's going to be reading your petition. They have no idea, you have to assume that they have no idea what you do. So, be able to explain in very simple terms, be able to be very clear, and have evidence and documents and documentation that backs up what you're saying, right? Especially if you are talking about how your work will bring about a specific benefit. I think it's really important to, be able to cite to sources that confirm that, credible sources, right? And this gets us back to, college days when we were writing, reports, and we had to do research to back up what we're saying. So, my approach to EB-2 NIWs is to keep it narrow, keep it simple, keep it easy to understand, and really just, have a theme and discuss that theme throughout the case. And that is, the final thing that I want the case to that's what I want the immigration officer to come out with knowing, knowing the theme of your case and understanding your case and understanding what you do.
Sweet. Thank you so much, Ingrid, for those tips to keep in mind. And yes, very well said. I think if testimonials were the same, talking about the same thing, it wouldn't make much sense. But if they're all different from one another, speaking good things about you, that would make a lot of sense. So that's one good point, Ingrid. And thank you so much for today. It was a very insightful discussion. We got to learn a lot from your expertise and your knowledge that you imparted in today's webinar. It was great to have you here today.
Likewise, thank you for having me.
Thank you so much, everyone, also for participating. And do not forget to contact Attorney Ingrid Perez. Her phone number is 407 609, sorry, 407 906 0068, and her email address is info@ibplaw.com. And go visit ibplaw.com to get to know more about Attorney Ingrid Perez. So Ingrid, also, we it's a busy season. So maybe if you have anything else to say to the audience, an end note maybe before we leave.
No, I'll just say that I do really enjoy working on these cases. If you'd like me to review your case, I do have a link on my website where you can go in there, send me your case information. It's a very detailed questionnaire that I ask people to fill out, and I do take my time reading those and sometimes researching the field before I invite somebody to come have a conversation with me. So if you want me to review your information, please visit my website, click on the link to get a free evaluation, and I will do that for you.
Thank you so much. And folks out there, yes, with that said, thank you everyone for joining us today on today's session here on Immigration Talk Show. It was great to have you. Do not forget to subscribe to us if you haven't as yet already. Hit that bell icon so that you get notified whenever we have important discussions like these. And absolutely, you can also contact me with your questions and whatever queries you have. Dial this number, or you can even WhatsApp me in this very same number, 408 335 6444. And my email address is nipa@staffingly.com. And also, you can check us out at www.staffingly.com. So, thank you so much, Ingrid, once again. It was great having you. Here's wishing you a happy Friday ahead and also a happy weekend that's coming up.
Likewise.
Bye bye.
Bye.